Okay, welcome everyone. Welcome to today's webinar. Really got an action-packed session for everyone. Today we're tackling the PAGA reform and just how to stay compliant in California's hospitality industry. We've got Beth Schroeder with us. Beth is a partner at Raines Feldman Littrell. She's a highly respected labor and employment attorney. She has over 30 years of experience. She specializes in helping businesses navigate the complex labor laws, including wage and hour compliance, workplace policies, and risk management. Beth is also a very active speaker. She's an advisor to several industry associations, including the California Restaurant Association. She's also been recognized as the best lawyers in America and as Southern California super lawyer. So we're really privileged to have her with us today. Today, she's going to be sharing some insights on the impact of last year's PAGA reform and really helping us to better understand the evolving compliance landscape. So without further ado, Beth, over to you.
Great. Good morning. Thank you, Caleb. Good morning to everybody. I know many of you are in Southern California where I am, where it's a lovely, beautiful, sunny day. Hope you're taking advantage of this incredible weather we have. Even though our topic is not quite as sunny, we're talking about the usually very dry, complex, and technical topic of wage and hour compliance, which is daunting, frustrating, intimidating, and all of the above. But we're here to give you a little bit of context to it and talk about PAGA, which is a very scary statute, but we'll break it down for you, and the tools and weapons that we've got that came out of the reform that we saw back in the middle of last year. So let's start with that and that background. People talk about PAGA, which is the acronym for the Private Attorney General Act, which is found in the California Labor Code. It is a creature that is specific to California. As many of you know, we have laws here that nobody else in the country has. And they challenge us. There's a price we pay for this beautiful weather in March. The PAGA statute was enacted in 2004. It was actually something that Gray Davis put into effect as Californians were booting him out of office and recalling him as governor. And he's one of the last statutes that he signed. So Gray Davis put the Private Attorney General Act into place because it was his belief that the state of California was underfunded and understaffed to hear and seek out the complaints that employees had about the compliance for that very technical California labor code by employers, and that employers were taking advantage of and abusing these employees. And by the way, there are those employers out there. Not many are ones I work with, but there are many, and they give employers and restaurants in particular a bad name. And it's one of the reasons that we get laws like PAGA, and we get laws continually being signed by the California legislature, who believes they have to make up for all those abuses. So it's because of those abusive employers that we sit with these statutory mechanisms that we have today. PAGA allows one employee to claim that they are aggrieved, that they have suffered labor code violations, and on behalf of all other aggrieved employees, bring legal action. The money goes in part to the state of California. That's where the private attorney general part comes in, and in parts to the aggrieved employees. And lo and behold, the attorneys get all of their fees and costs. And that is, of course, the tail that wags the dog in these cases. The individual employees get pennies on the dollar. The state of California makes a bundle and has made billions on these cases. And so have the plaintiffs' attorneys that bring these cases, because they get a percentage of that recovery. The old PAGA, as we're going to call it for today, which is the original version of PAGA signed in 2004, said that 75% of that money went to the state, 25% went to the harmed or aggrieved employees. Even if they themselves did not claim that they had a violation, they were automatically included. And again, the attorneys get their fees. So PAGA became a runaway train, truly a runaway train. And the kinds of lawsuits we were seeing and the abuse we were seeing from PAGA lawsuits became prolific. There have been a number of court decisions, both at the state and federal level, that have impacted the development of PAGA and how we get where we are. There was a very important decision in 2013, Iskanian versus CLS Transportation, that held that PAGA cases were exempt from arbitration and class action waivers. Class action waivers, by the way, for those of you who know, are agreements that are enforceable and that we get signed by our employees that bar them from being representatives and being able to bring class actions. But the Iskanian case basically carved PAGA cases out of those class action waivers, stating that because the state of California was a party to the action, that they were not enforceable. Then we got the 2020 Kims v. Raines case. It came down literally as the pandemic was hitting us in March of 2020. That said that we can't receive separate settlement agreements for employees to be able to waive their rights, and that we could not use those settlement agreements as a tool to defend our employer clients from these PAGA cases. In 2023, we got a gift from the gods, essentially. First we had Viking River Cruises, and then we had the Adolf case. So the Viking River Cruises case came out and interpreted and said that the Federal Arbitration Act preempted all of these cases and that class action waivers might be enforceable. They sent or left a loophole open for the Adolf versus Uber case, which essentially says that class action waivers can be enforceable, but all that means is that the individual employee gets sent to arbitration first to determine whether the employee is truly aggrieved, and then the rest of the PAGA case will get heard. So we're back to PAGA cases are not really waivable under class action waivers, but we get an additional step out of the Adolf versus Uber cases. So in the meantime, from 2004 up through now, which is 21 years later, we see on average 150 new PAGA letters being filed against employers every week, sometimes more. Billions, like I said, have been awarded to the state of California, and the employees themselves usually receive sometimes literally $1 or $2 out of these settlements. That's the backdrop under which we get to what happened last year. So very quickly, to let you all know sort of the background and the context of how we got a PAGA reform, because I was screaming about it for years and I was told there's just no appetite. Efforts started before the pandemic to put together a ballot measure that would either reform or gut PAGA because of the extreme effects we saw on businesses here in California. That effort finally came to fruition. It was determined that it would best to put the ballot measure on the presidential ballot because more people vote. And so the ballot measure was put on the 2024 ballot to basically what would have gutted PAGA. Whether that ballot measure would have been successful or not is tough in California, but it was leverage. And so what it did is it forced legislatures and the governor's office to finally sit down and take a look at PAGA and say, okay, fine, we don't want this ballot measure going forward and taking PAGA off the table altogether. We're afraid of what the voters might do, so let's reform it. And that's the first time we got the attention of the legislatures and the governors on this. There was a coalition put together, the California Restaurant Association, the Chamber of Commerce, some other business group that came together and worked with labor unions and other employee groups and came up with now what is the reform of 2024 that went into effect technically July 1st, but really for any cases filed after June 19th of 2024. And let's look at what we got out of that reform. So what does the new reform do? PAGA, the way it was written, involved penalties for violations. So as you all know, if an employee fails to take their meal break, they get a 1-hour premium pay. But that's not what PAGA gives them. What PAGA gives them is a penalty for every payroll period where it's determined that employees at your company didn't get the proper meal break. So it isn't every employee, it could just be employees in general. And then it's determined that because the employer was not in compliance for that payroll period, every employee will get $200 per payroll violation for each violation, going back 1 year from the PAGA letter. And we were seeing them bring lists of 20, 25 different violations. So you can imagine when you stack all those penalties, what happens and how those dollars get so big. Well, the reform does a number of things. And the first thing it does is it cuts those penalties in half. So instead of starting at $200 per payroll period, it starts at $100. And if some of the payroll keeping violations actually start at $25. So it literally cuts the dollars in half or down to a fraction of what the potential violation cost could be. Then it changes the percentage of the settlement. Now 65% goes to the state, 35% goes to our employees. It undoes some of the bad court decisions. There were some decisions out there that questioned what the statute of limitations would be, and the standing of the employee. And in particular, it's now determined that an employee can only bring claims that they have themselves suffered. So there was a court decision out there that said that if an employee is aggrieved, let's say they missed a meal break, they could also sue for not getting their expenses if they're a driver, even though they're not a driver. So that case is erased essentially. And now the employee actually has to be impacted themselves to bring those same types of violation complaints on behalf of the other quote unquote aggrieved employees. Also, if, like I said, PAGA is a payroll period calculation. So if you were paying weekly instead of every other week or semi-monthly, you were punished because there were more payroll periods in the PAGA period. But that's no longer the case. It's been corrected. So now if you're paying weekly, you're not harmed. You're basically, your violations are measured the same way as if you were paying every other week. It allows employers to cure. And if you have 100 or fewer employees, there is a cure that goes into effect in a very short amount of time after the PAGA letter is received that goes through the Labor Workforce Development Association. And if you are larger than that, you can cure by going through an early evaluation conference once the case is filed. Curing is going to be a remedy that we use in very select, discrete circumstances because it can be very expensive if there are a lot of violations, or it can be hard to do if there's a lot of off-the-clock work that we can't estimate. But it is there as a remedy, and we're already starting to use it for our clients. And this is the big one. This is the big, big reward that we got out of the PAGA and what we're going to talk about mostly today. If an employer is deemed to be the good guy, a compliant employer, there is a huge reduction in the penalties. And that's okay. Go to the next slide because we'll break that down in particular, because this is the big benefit that I think is what everybody should be talking about with this PAGA reform and why we're here. So if employers are considered the good guys, are doing everything right, which for my clients is most of them, they're rewarded. They're not measured the same way as those abusive employers that really the state is targeting with this. So if employers take, quote, all reasonable steps to comply, and that's out of the statute, then if they did all of those things before a PAGA notice, before a PAGA letter gets to you, and by the way, just segueing for a minute, the way these cases start is there is a letter that is served with the LWDA, the Labor Workforce Development Association Agency. And that letter is filed by the attorneys for the employee or the employees. It gets served certified on the employer. And that letter will delineate what those violations are, who the employer is and what the violations are. Sometimes they have a laundry list, sometimes they have just a few violations, but that's basically your version of the lawsuit. There is then a lawsuit filed afterwards, but that letter has to be filed with the state at least 65 days before a lawsuit can be filed. But it's extremely important for us to get a look at and get our hands on that PAGA letter as soon as possible, whenever you guys get it, because these percentages get triggered. So if you're considered to be a compliant employer and doing everything right before that letter gets to you and is filed with the state, then those penalties I talked about are reduced by 85%. They're reduced down to 15% of what they otherwise would be. So think about that. If someone's coming in and asking for $1 million, now you're talking about 150,000. Yes, those are still big numbers, but that's a starting point. And then we negotiate from there. So these cases, the kinds of dollars that people are looking at are substantially reduced if you're considered to be a compliant employer. Now, even after you get that PAGA notice, if you haven't done everything right, and we're going to talk about what compliance means, you can get yourself, quote, into compliance within 60 days and then get a 70% reduction in the penalties, so that the penalties are capped at 30%. And this is only for PAGA letters that were filed with the state of California after June 19th, 2024. Now, mind you, the reform was announced the last week of June. The reason that deadline became important was that the state had until June 26th to reach a compromise before the ballot measure would go forward and you couldn't be pulled from the ballot. So this ballot measure that was out there hanging over everybody's head was the key to all of this. This reform was announced basically on that deadline. But of course, plaintiffs' attorneys who were not paying attention ran out and filed, I think, 700 PAGA letters in 1 week, in the week after that reform was announced, not realizing that they backdated the effective date of the reform to June 19th. So they all missed that window. So it was kind of funny to watch the PAGA letters all come in. Like I said, and there was one law firm in particular, I won't shame them by name, but there was one law firm that I think filed 400 or 500 of those letters. That means that they were all sitting there waiting to be filed. They'd filed them all in 1 day, but they missed the June 19th window. So let's break down what is compliance under PAGA reform, because again, while we have that cure window, really being a compliant employer is how we win these cases and how we win using the PAGA reform. So let's talk about that. So the statute gives examples of what they would consider to be compliance. Now, do we have to do all of them? I don't know. Keep in mind that we don't have any reported cases that have been decided under this new reform. We won't have any reported cases under this reform probably for 5, 6, or 7 years, because cases have to go to trial, then they get appealed. All those things have to happen. We're going to be lucky if we get decisions on this in the next decade. But here is what the statute says. The statute gives us 4 examples of being compliant, and I wouldn't take the risk. I would do all of them. Why not? Let's make sure that we are the quintessential definition of compliant employer to be able to take advantage of these cases and push down the amounts of settlements in these cases. Or if we choose to take it to trial, we can win these cases. So first, create and implement legally compliant written policies. We prepare handbooks for many of you, and you have to make sure that you are implementing them, getting them signed. We update these employee handbooks every year. If we don't do your handbooks and you don't know if your handbook is compliant, feel free to send it to me and I'll give you a little freebie look at it and tell you what it might need and what the cost might be. But if you're with our handbook program, you know that you at least are starting with a written compliant policy. Now, again, I say that you're starting with it because we often find that our clients, unbeknownst to us, are handing out written forms policies, or your managers are handing out written forms or policies that contradict the employee handbooks that we prepare. So that's where, you know, one of the next, actually the third one comes into place, and that's audits. Make sure that you're having all of your onboarding materials, your forms, your documents, everything that you're using reviewed, audited, checked and double checked on a regular basis, because managers are constantly introducing new forms that maybe they got at a different company, but who knows where they got that, and it could be from out of state, and it may even be not a compliant policy or form, even though they got it from a very big company, which is what we're told all the time. So make sure that you're getting all those forms reviewed. Conduct periodic payroll audits. And I think we don't know what they mean by this, but I break it down into two steps. One is to have a legal audit conducted, which is people like me sitting down with your team, going through your practices and procedures, making sure that everything is in place the way it's supposed to, that your meal break policies are in place, that your off the clock policies are in place, that your procedures, that you've got everybody classified correctly, exempt versus non-correct. You're not using independent contractors when you shouldn't, 1099 employees, which isn't even a thing, looking at your tip pools, your service charges, etc., going through all of that. Then once we have that in place, and once we determine that you have the proper procedures, forms, documents, and policies in place, doing your own periodic payroll audits to make sure things are running the way they should. Because even when we put those policies and procedures in place, sometimes glitches happen. Glitches happen technically, glitches happen with employees, people aren't following the rules, people are changing time when they shouldn't be changing time. So your own internal audits to double check and make sure that the policies and procedures we put into place that are compliant are being followed and being implemented correctly. If you find that there is a mistake, oops, for some reason that meal break premium didn't get paid in that payroll period, or look, in California, we have, I don't know what, 50 different pockets of minimum wage, and maybe we didn't implement a minimum wage hike on July 1st or January 1st in one location that we thought, or we got the wage wrong. Take immediate action and make sure that you correct that. You go back and you correct the minimum wage. You issue corrected wage statements, all the things that you need to do to correct issues that you find yourself. Finally, and that's why some of you are on this program today, training your managers on wage and hour compliance. Make sure that you sit down with your team and that your team knows what is appropriate, what is legal, what is compliant. We can't hold managers accountable unless we give them the proper training, resources, and tools to conduct their business. They're on the front lines. They're the ones who are implementing these policies and procedures. But none of this stuff is intuitive. These are technical laws, and no one is going to know them unless we train them. And usually when we promote managers, we're not sitting down and having them going through training classes. We're promoting them because they were a good server, they were a good bartender, they were a good host, they were good at whatever they were doing. And now we're promoting them to manager. But who tells them how to be a manager? That has to be on us. That is our job, that is our role. So sit down and make sure your managers have the proper training to do their jobs. We as companies and employers are only as strong as our weakest link managers. So let's bring all of our managers up to make sure that they have the knowledge and information that they should have. And then you have become this compliant employer for purposes of PAGA. So it's a win-win. So getting real, I think I talked about this already. So this is kind of a refresher slide. When we're looking at those 4 buckets, make sure you're updating all your written policies. Let's look at your wage stubs. Let's look at your form. Let's look at your onboarding packages and agreements. And like I said, don't let managers distribute random forms that have not been cleared through corporate entity HR. Conduct legal audits of all your wage and hour practices. Like I said, exempt, non-exempt. I have a 7-page checklist I go through with people. Are you doing your sick leave properly? Are you calculating regular rate correctly? That's a wonderful one. We will spend time going through all of those questions because those are the things that people get wrong all the time. Then correct any questionable practices. Better that I catch these things than a lawsuit catch them, and make sure that we're doing things right. Train your managers, like I said, early and often, nothing matters otherwise. They are the ones who implement these policies. And then check in with your employees. Do periodic surveys. Do your own internal audits. Be in the restaurants, be in your locations, talk to people, make sure that you're checking in to see that people are getting their breaks. People aren't working off the clock. There's no way for us to know unless we find those things out. So let's start on what those rules are. That's why a lot of you I know are here. What are the rules? And like I said, I get that we get confused on the breaks. Mediators get confused, judges get confused, attorneys get confused. These are confusing laws. And so that's why I talk about training, because as often as we talk about it, our managers get confused, and understandably so. So let's make sure that we have it in writing correctly, and then we're reminding people what that really means. So meal breaks. Employees are entitled to a 30-minute uninterrupted, nonstop, duty-free, completely duty-free meal break of 30 minutes, not 29, not 28, 30, for every 5 hours that they work. That meal break opportunity must be provided no later than the end of the 5th hour. And why does everybody talk about 6 hours? Why people are like, wait a minute, I thought it was 6 hours. Because that meal break can be waived, and it's waived in writing, although the policy doesn't, the law doesn't say it has to be in writing, but it better be, because otherwise people will argue that they didn't do it. It can be waived by mutual consent if the employee's shift for the day is no longer than 6 hours. That's where the 6 hour issue comes in. We can do 6 hour waivers. We have 6 hour waivers. If you're questioning whether your 6 hour waivers are compliant, shoot them over, or I can send you one. We have them in English and Spanish. They don't have to be signed multiple times a day or during the workplace, because we have them sign it once. We keep it in their personnel file. It's done. Do not lose those waivers. But if an employee is working more than 6 hours, 6 hours and 1 minute, and they didn't get their meal break within those first 5 hours, then you have a violation. And that is why we get so many of the cases we get, especially in this hospitality industry. Now, employees are entitled to a second meal break if they're working 10 hours, but that also can be waived if the employee works no more than 12 hours. So the same waiver can address both the 6 hour issue and the second meal break issue. The employee can waive it as long as they took the first meal break. If they didn't take the first meal break, you're in violation anyway. And you're going to be paying a meal break penalty or premium. So that's the law on meal breaks. And I know we'll probably have questions, but I can take the questions at the end too. So meal break doesn't need to be paid and is usually not paid, but it has to be completely relieved of duty. When do we get the biggest problems? We get problems with anybody who's carrying equipment. If you're carrying a pager or a phone that gets interrupted, or hourly managers. And that's a lot of your people. A lot of people are hourly managers, and they're sitting and taking lunch, and they get asked a question while you're taking lunch, and you're like, what's the big deal? Or we get it in the legal industry. Our assistants eat at their desk, and a partner comes over and asks them a question. I've done that with my assistant. I've walked over and started to talk to her, and she's like, I'm technically at lunch. I'm like, okay, don't answer, go back to lunch. We are not having, she's like, no, it's okay. No, it's not okay. It's not okay to interrupt our employees with quick questions, even though it's 30 seconds. That is now an interrupted meal break. Now, there are two things you can do if there's an interrupted meal break. Number one is you can pay the penalty for not giving somebody an uninterrupted break, or you can start the break over again and start fresh at 30 minutes, but they need to at least 30 minutes uninterrupted. And we get this allegation all the time. Like I said, don't confuse the 5 and 6 hour marks. Employees always have to get a break within the first 5 hours, unless 6 hours ends their shift for the day. But that is the only time. Otherwise, ingrain that 5 hour rule in your mind. Your back of the house, heart of the house, kitchen employees who are almost always working more than 6 hours, just assume that they can't waive their breaks. And for our full-time employees in office setting, we're always going to be over 6 hours. So they always have to have that meal break within the first 5 hours. If they do not, they get 1 extra hour of pay. Now, I know everybody calls it the meal break penalty. It is technically not a penalty. It's technically premium pay. And there are a couple of reasons why we don't call it a penalty and why I try to watch my verbiage on it. It's sort of like pregnancy versus maternity leave. We don't have maternity leaves. We have pregnancy disability leaves. Premium pay gets calculated at the regular rate. So remember I told you that regular rate calculation is one of the things we talk about in our audits. If you have employees who have different rates of pay during the week, if you have employees who receive part of a service charge or service pool, those employees are going to have fluctuating regular rates. And that is relevant for determinant of overtime. It's also relevant for the payment of these meal break premiums or penalty pay. You can automatically add the 1 hour of pay. Let's say you have hourly managers, you assume are getting interrupted. Keep them on the clock, keep them paid, pay the 1 hour extra meal break, and now they can take all of their meal breaks, 2 or 3 in the day. And if they get interrupted, it's no big deal because you've paid the 1 hour meal break premium for that day and you're golden. It's all you have to do. Those meal break premiums should be clearly delineated on your pay stub. By the way, the reason I do this program with Push is because they are so good at this California compliance stuff. And the reason I know they're so good is because they consult with us about it and they make sure that they're following the law. But they are very good at helping break down these meal break premium designations on your pay stubs. We should be able to look at your pay stubs when we look at compliance and see if this person worked through 6 hours, we should see 1 hour of meal break pay on their pay stub. If that isn't happening every single time, you have a non-compliant meal break problem, and that's going to get you sued every time. Don't even think about on-duty meal breaks. It's not going to be relevant for anybody here, maybe ambulance drivers, but that's about it. So I'm not even going to talk about it because, I think we've gotten good at knowing that we've thrown that term out of our parlance. Should you implement an automatic break pay system? If you're in the hospitality industry and you are a target or retail, I would say yes. I don't know if it's as important for law firms and white collar industries, although we're starting to see these lawsuits in industries like ours. But definitely if you're in an industry such as hospitality, where, let's face it, we're the busiest during meal breaks, mealtime, because that's when we serve our guests. We serve our guests during lunch and dinner and breakfast. So making sure that, and also there's an incentive for people to work through because often they're tipped. And so we see that a little bit less in fast food or fast casual, where the tips either aren't there or aren't as high. But in any kind of dining where we see tipped employees don't want to take a break. They want to keep working and they want to take care of their tables and they want to provide good service. So it's counterintuitive for someone to say, hey, I need a break. It's time for me to sit down. Most of them would prefer to work through, and sometimes will accidentally work through. So catching these when somebody goes a minute over, or when someone gets interrupted, or when a break is short, we don't want to give you all that work. You're going to miss it. No matter how many people look at the payroll system, you're going to miss it. Just automate it. People like Push can help you automate it. But whatever system you use, automate that meal break premium pay, and then check to make sure your automation systems are working properly. Because in these high risk industries, like I said, hospitality, manufacturing, retail, just sleep at night. Don't even think about it. If you don't have an automatic payroll system paying it, then absolutely audit your records regularly. And like I said, we're seeing law firms now hit with these PAGA and class action suits. White collar industries we're seeing. So make sure whatever industry you're in, but especially if you're in a high risk group like hospitality, to make sure that that there isn't a payroll that goes by that you haven't checked every entry to make sure that you're paying these meal break premiums. It is still the #1 area we see hit for PAGA and class action lawsuits. So rest breaks. I actually went hiking yesterday after work, and a client called me, and I sat at the top of the hill for a half an hour and talked to her. And this was one of the topics. She's like, "What do we do about rest breaks?" And I'm staring at the beautiful mountains and the hawks circling and talking about, do we do an automatic payroll for rest breaks? And I said to her, as I say to you, that rest breaks are the burden and bane of all of our existence, especially in this industry. So let's talk about the rules, and then we'll talk about the reality. The rule is that employees are entitled to a 10-minute uninterrupted paid rest break for every 4 hours worked, quote, or major fraction thereof. If you don't have that language in your written policy, it's already on its face non-compliant. So the way that works in practice and the way the courts have interpreted it is that means that they get a 10-minute break if they're scheduled for 3.5 to 6 hours. They get two 10-minute breaks if they're scheduled between a minute over 6 and 10 hours. And if they work more than 10 hours, they get 3 rest breaks. And there may be circumstances where they get 4, but most of you don't have those circumstances. I talk here about the Augustus versus ABM case brought by my good friends at Diversity Law Group. And really what that case held, it came out in 2018, and it was a case involving security guards. And the security guards were required to carry their pagers on their breaks, even though they were given their breaks, and they were often the only ones there, and it was often very slow, and they could sit down, they could eat and do all these things, but they had to keep that walkie-talkie on and that two-way pager on all the time for security purposes. So they really were never fully relieved of duty. And that's what the court held, that even if they weren't interrupted, they could have been interrupted. And if they were kept on call, then and they were prohibited from leaving the premises. So we went and changed all of our policies after the ABM case to make sure that, and this is one of the things we look at, that your policies don't say and your managers aren't telling people, oh, you can't leave the premises on your rest break, or you can't leave the premises on your lunch break. Employees have to be allowed to leave, even if they can't get very far in 10 minutes. We can't have those policies that say that they're not allowed to leave. If they are not allowed to leave, it is a non-compliant rest break, and they have to get a rest break premium, an extra hour of pay, just like if the employees missed a lunch break. And everyone's like, well, why do they have to get an extra hour? They only missed 10 minutes. That's what the labor code says. They get the extra hour if they missed a rest break. They get an extra hour if they missed a meal break, one for each day if they didn't get all of their required breaks in that day. So how do we determine if there's compliance with rest breaks if we don't have people clocking out for rest breaks? Well, number one, you obviously have to have compliant written policies. But, do you have people punch out for rest breaks? The problem with people punching out for rest breaks is if you don't have 100% compliance, you're going to have to pay a rest break premium. Do you want to do that? Fast food may do that. Casual dining, fine dining usually does not. But there are different ways that we can find to comply with rest break and make sure that our employees are getting rest breaks as well. Change the conversation within your stores to make sure that rest breaks are offered, not that you wait for people to come and take them, because sometimes it's just too busy to take them.
Beth, a quick question in the chat, just while we're on rest breaks, does it include bathroom breaks?
Well, employees can go to the bathroom, they can go get a drink of water, they can go get food on their rest breaks, but we don't total all the bathroom breaks and say, hey, you got your 10 minutes. They need to get a window of 10 minutes somewhere. Now, it may be they need to go to the bathroom more often than that. I don't think that we're going to, I sure wouldn't want to be, chastising or disciplining an employee for taking an abundance of bathroom breaks. I say that, and yet I get questions from clients and have over the years. And by the way, I'm actually in my 40th year of practice, so I'm well over 30 years of practice. And in all those years, I get lots of questions with people saying, we have people going to the restroom and they're taking 15 minutes every time they go, and they're going every hour. Look, that's probably worthy of a conversation with your employees, and those are one-off situations. Call me and we can talk through that. But for the most part, I wouldn't be worrying about bathroom breaks and, are they adding up to 10 minutes? Just make sure people are getting a full 10 minutes. The smokers always seem to do it. But the strategy for 10-minute rest breaks is a constant conversation. And one of the things that I've always liked about the push operation system is that it allows for post POS, post shift communication with your employees to ask them, have you received your rest break? And if not, to implement that 1 hour pay, or to have, why didn't you receive it? So there are ways to script the program to allow for that dialogue with employees. I do have several clients who are doing these post POS shift questionnaires, whether they're doing it automated or they're doing it in writing, and asking employees, did anything keep you from getting your 10-minute rest break today? And if they say yes, then pay them an extra hour. When we take these cases to mediation, if we have clients that are paying rest break premiums, we are already way ahead of the game. And it may not be a lot of rest break premiums, but look, your managers know when it's so crazy busy that people couldn't get a breath to take a rest break. When it's like that. So maybe you automatically go ahead and pay the 10-minute rest break premium on those very busy Sunday brunches or Saturday nights, whatever the case may be. It's a cheap insurance policy to do it and not get hit for these I didn't get my rest break policy claims. So what else are we seeing? We're seeing a lot of other types of claims trigger these PAGA cases besides meal and rest break. The off the clock one is big. It's like one of the big popular ones. We saw it during the pandemic that people claimed that they were off the clock during their temperature and system checks. That's why we harped on all of you so hard to make sure that you were either adding time into your employees' pay or making sure that they were clocked in before you had those conversations about symptoms and temperature checks during COVID. But one of the things that we saw comes out of a case called Troyster versus Starbucks in 2018. Again, the California Supreme Court, that basically said there's no such thing as de minimis time in California. And in this Troyster case involved a shift supervisor who had the keys and would lock up the door after he clocked out and would turn on the alarm and would unlock the door and let people in. Or sometimes if an employee forgot something, would have to open up the door again, allow them to get back in. Those kind of things take 30 seconds, a minute, 2 minutes max. But the California Supreme Court said if you add all that up over Mr. Troyster's 15 months, it came to, I think, $182. And they said that you could pay a utility bill with that. Well, they must not have my utility bills, but anyway. It's, we all know that it literally is a 30-second or a minute or a 2-minute process at most. But since there's no de minimis anymore, we have to make sure that our hourly managers, and there are a lot of them, and there are probably more that even should be hourly that aren't, get paid for these small amounts of time. What if they get a text when they're off the clock from an employee asking about a shift? That should be recorded. And that's true for any of our employees. I have my assistants who, now that everybody's on email, the pandemic had us all put our emails on our phones. So my assistants will sometimes just respond to questions that I ask them that aren't meant to be responded to until the next day, but they respond because they have their phones in front of them. I'm like, stop working. So we can't have people working on those little issues. Figure out a way to get your employees paid. Either do a survey every month and ask them if they worked off the clock that month and pay them, or build in an extra few minutes every payroll period to cover those little bits and bobs of time, because most hourly managers are going to have them. A lot of other employees may have them too, but especially our hourly managers and shift leads and people like that. So watch for that. Waiting in line for bag checks. That was a case that came out of the Apple case. Employees who had to wait to have their bags checked for security, even though that may be 30 seconds, again, going and coming. And the court said that over a period of time, that adds up to significant time. Added back in, waiting for gates to open, waiting for doors to unlock, waiting for security, walking down long halls after they clock in. Count all of that. The donning and doffing cases, I had a case where somebody argued that they had to do their hand washing before they clocked in. Make sure that they're washing their hands, putting on any kind of safety equipment before they're clocked in. Reimbursement for out-of-pocket expenses. Labor Code Section 2802 under the California Labor Code says that employees can never be held accountable for business expenses, which means if they're working at home, like I am right now, Wi-Fi, cell phone, internet, electricity, doesn't have to be a lot of money, especially if they're not working at home much. Cell phone. Most of our employees use their cell phone for something. Even if they're on a plant and they're there in person, they're taking pictures of things and sending it to a manager. They're asking a manager, instead of walking across the floor, they're texting their manager, even when they're all on the clock. If they're using their cell phones for work, and we know they're using their cell phones for work, instead of making rules around prohibiting them, just pay them $1 or $2 per week, $1 or $2 per pay period. A small amount. If they're using it more, pay them more. Obviously, hourly managers are using it a lot more, but our staff are using it. They're using it to clock in and out. They're using it to check their schedules. They're using it to communicate with each other about work-related issues. Just build that in. And mileage. If employees are driving any kind of errands, I had a claim for one of my clients. They had an employee who worked for them for, I think, 20 years. He made a meal break claim. It turned out the meal break claim wasn't valid, but it also turned out that that employee would stop at their bakery and pick up bread for the restaurant every day on his way into work because he lived right next door to the bakery. No big deal. Unfortunately, if he's carting that bread in and out on his drive into work, that is no longer commute time. It's now work time. And if your managers are running quick errands between restaurants to pick up things or on their way in, you're out of forks and they stop and they pick that up. Of course, you reimburse them for the forks, but you also reimburse them for their drive time and their mileage. So we get these cases too. I'm not even going to spend a huge amount of time talking about salary versus hourly employees because that is something we'll cover in an audit. But let's just say, suffice it to say that paying somebody the minimum amount of salary in California does not make somebody exempt. They have to be spending more than half their time doing exempt duties like hiring, firing, scheduling, and training, which very few of our managers do. So very few of your managers should be exempt. Very few of your employees should be exempt. Almost every company, in fact, I think every company I've ever audited has misclassified employees. Let's make sure we go over that list. And if an employee is either working permanently or some regular status remotely, even if it's a day a week or 2 days a week, make sure that you're giving them that work from home stipend. But also, if they're then coming into the office and they're normally working at home, that becomes commute time as well. So this is a lot. We've talked about a lot, and we're getting to the end, and we're getting to the questions and answers part of this program. But I wanted to let you know how we can help you navigate all this. And we've been doing this for a long time, but especially with the PAGA reform, we want to make sure that you're all taking advantage of these amazing tools and weapons we've got out of the reform. So number one, we can obviously update and prepare your employee handbooks. I think we do hundreds a year. And review all your new hire documents, any forms and written policies that you're using. And by the way, make sure you have a compliant arbitration class action waiver in there. It won't get you around PAGA, but it will still get you around those gnarly class actions. The audits I've talked about, the audits involve an hour to 2 max jumping on a Zoom usually and looking at all of your documents and going through your practices. I don't think I've had one go longer than 2 hours. Most of them go between an hour and 90 minutes. And then we've literally gotten into the corners of your closet and looked at all the cobwebs. We've cleaned everything out, and you know that you can at least put in practices. Even people who tell me, oh, I'm sure we're really good, I will find things. I guarantee you I will find things. This is what I do for a living. Once you find the problems, you have to fix them. Sometimes we don't know about what's happening except from our employees. Make sure that your employees are comfortable coming forward. Do surveys, have anonymous reporting. This is one avenue, which is an app that I'm involved with. But whatever you do, make sure that your employees can come forward and alert you to maybe a rogue manager having people work off the clock, which you may not know about sitting in corporate, but it may be happening. and training. Training is a lot of what we're doing right now. But make sure we're doing a one-on-one training where your managers can ask questions, where we can sit down and talk about what's happening in your locations. And as often as we have training, I do them every few years and get a whole new crop of questions and sometimes new legal issues that come up. So make sure we're sitting down with your team. And again, doesn't always have to take more than an hour, just going through some of these rules. I did a panel several years back, and I was asked, what is the best way to stop employee lawsuits? And I always say, treat your employees well. I can tell you from the clients I've represented, some of them have been representing for well over 30 years, who are the ones that do it right, because they don't get a lot of lawsuits, and they have a long-term, employees, and they don't have as much turnover. That's all a testament to what you all are doing right. But I will also tell you that even if you're doing everything right, it only takes one employee to bring one of these PAGA suits for every other employee who's there who may be happy. So the compliance is important too. So a bit of good news, I'll leave you all with this. Those of us who do this industry have been frustrated for years with both the California legislature and just some of the things that we feel like lawyers can get away with. By the way, I will also tell you very quickly that our trial team, my partner Lauren and my associate Frida and others who helped with the case, got a successful jury verdict. It came in yesterday on a trial that lasted, I think, 2 months on sexual harassment. So we are getting victories. It's very, very gratifying, especially when these attorneys are so smug about the fact that they always win. They don't always win, but trials are expensive, very expensive. One of the ways that the train is being slowed down is, believe it or not, the state of California. So as I reminded you, for PAGA cases, in order to instigate and initiate the PAGA lawsuit, attorneys have to file a PAGA letter, which claims all the violations, and they have to file that with the Workforce Development Department, the LWDA, before they start their lawsuit. For the most part, that's just been a perfunctory process. Supposedly, the state will look at it and determine if they want to prosecute the case. They never do. The 65 days run and everybody moves forward. Well, in the past month, there was a situation where the LWDA actually called one of these really abusive law firms on the carpet and looked at all of their letters that they had filed since January, which, by the way, I think were 170 letters from January until February of this year. That just shows you. I think they've had 700 letters, and basically sent this law firm a letter that said, you have to rewrite all of your PAGA letters because these letters are boilerplate. These letters have malicious allegations, and they've actually threatened to report this law firm to the state bar if they didn't comply, which is a pretty heavy penalty. So that means the state is taking a look at these things, and we're making some progress. But we have things we can do too. So make sure that you're doing your homework on your end and taking advantage of the steps that we got from this PAGA reform. So I'll let you all ask questions, or tell me what the questions are at this point, Caleb.
Thanks, Beth. Appreciate it. That was a lot of very valuable information. Really appreciate it. We're going to go through a couple of the questions. First one is, if an employee has a 10-minute break violation and a meal break premium in the same shift, do the employees get an extra hour of pay for each violation?
Yes. So they get a separate meal break penalty pay for every day that the employee didn't get all of their meal breaks, and then another rest break premium if they didn't get all their rest breaks that day. So technically they would be entitled to 2 different penalties in the same day, but only 2. So even if they didn't get any of their rest breaks and they were entitled to 4, they would still only get 1 hour of rest break premium pay and 1 hour of meal break pay for that 24-hour work day.
Perfect, thank you. Is regular rate of pay calculation the same thing as weighted time average calculations?
Yes. But it's a little more complicated than that, because regular rate of pay isn't just about two different rates of pay, which is what weighted time calculation talks about. It also takes into account service charges, bonuses. Let's say you pay a bonus every quarter to your, or maybe you have a contest where you're paying employees for meeting certain goals, or you pay them extra money if they're if they're selling up a certain product. Any kind of extra incentive pay, anything like that, needs to be added into the regular rate. It's a complicated calculation. We can help you through it. We have the formula, but make sure that you're looking at this issue, because almost every employer has some regular rate situations. The things that have to pay at regular rate are overtime, break pay, sick pay, and reporting time pay.
And what verbiage or statement would you recommend including when employees sign their timesheets to ensure clarity and accountability?
There, people love to put sort of disclaimer language on timesheets that they think is going to get them out of lawsuits. And for the most part, plaintiff side and attorneys ignore that language, because they know and we know that signing it just means they're doing it to get paid. So even if you have someone shaving their time, and if they said, I count that all my hours are true and correct, if we can show that someone's been shaving their time and it's been doing it to cut off meal break premiums or overtime, having them sign disclaimatory language every time is not going to save you. So really, it's about your practices and about your manager's practices and what we're doing, especially with time edits. And now I would have the employees' initial time edits in real time. That to me is way more important than signing something at the end of a payroll period about the accuracy of the time records.
Okay, perfect. I know we've got quite a few more questions in. We'll make sure to answer those questions and send everyone a response via email. If you do want to connect with Beth post-webinar, please go check out her website, Raines Law. Her contact details are there, so please feel free to get in touch with her. If you're looking to automate a lot of these solutions, make sure compliance is sort of automated, built in your systems. We're offering 3 months for anyone who's attended the webinar. So please also go to the Push website and feel free to sign up for a demo, and we'll show you how we can help you with these compliance issues.
And if you have anything you need, my contact information is there. As many of you know, I also do a Monday blog. I do most Mondays. If you want to subscribe to that and get on the mailing list and you're not, please let me know. I can add you to that. Or you can even go to the site mondaymorningbriefings.com and subscribe there. And I push out a lot of information on those blogs. But I really want to give a kudos to the people at Push. They are extremely innovative and creative about trying to provide these solutions for us in an automated fashion, and to be flexible in responding to the needs of California employers, which is why I work with them on these programs. So if you have an issue, I know some of you already use them, reach out to them. This is what they do, and this is why we work with them.
Fantastic. Thank you so much, Beth. Thanks for today. Thanks for all the insights.
Good to see you all. Thank you,
us.
Caleb. Thank you, Emma. And I'm sure we'll do this again soon. Have a good day, everybody.
Thanks, everyone. Bye.